Our Constitution provides in Article 12 that all persons are equal before the law and entitled to the equal protection of the law. Today, I wish to focus on the challenges of litigants who do not have lawyers. I will highlight cases from the ground to illustrate difficulties they face in normal times and in COVID times. At the onset, I wish to acknowledge the attention that the courts have been paying to the litigants in person. There are training programs at the Singapore Judicial College to sensitize judges on how to handle such litigants in court. Lawyers also see judges going the extra mile to explain to unrepresented persons the requirements of the law and legal procedure. There are also inquiry counters at the courts and education brochures in the 4 official languages. My purpose is not to criticize current efforts, but to highlight some observations from the ground for the court's consideration for possible further enhancements. There are 3 main challenges I wish to highlight. First, non-English speaking litigants. Second, the need for public buy-in of court procedures. And third, particular challenges caused by COVID-19. First, non-English speaking litigants. It is common at my Meet People session to encounter Chinese-speaking residents showing me court documents and saying that they are unable to read them and do not know what they should do next. Indeed, according to the General Household Survey 2015, there remains nearly 20% of the population above 15 years old who are not literate in English. I am aware that court interpreters can be applied for in advance of court hearings and are available for Mandarin, Malay and Tamil, and other specified languages and dialects. However, this has to be applied for through e-litigation in advance, otherwise deployment will be subject to availability. I wonder if many litigants in person have used e-litigation to apply for such interpretation services. As for court documents, they are issued in English. Residents sometimes tell me that they do not understand the contents of orders made by the courts. As the national language policy recognizes Chinese, Malay and Tamil as official languages, I wonder if the courts could consider providing translations of court-issued documents to litigants in these languages, either for free or for a nominal fee. If this is not possible for all documents, then is it possible at least for court orders, so that litigants are clear what is required of them? My second point is the need for public buy-in of court procedures. To illustrate the point, I note some unhappiness from residents who had their neighbour disputes adjudicated by the CDRT, which was discussed in the earlier COS. The unhappiness was both about the hearing and the outcome. To this end, I would hope that CDRT judges are specially selected with empathy and patience as key traits and also have the ability to explain issues to litigants in simple and vernacular language. As for the orders made by the CDRT, some residents are shocked to be ordered to stay out of their homes for a few weeks. After all, this is a most drastic order that undermines their property rights. Finally, additional difficulties caused during the COVID pandemic. The courts had to close for several weeks during the circuit breaker and continues to restrict physical hearings and counter services. There must now be a significant backlog of cases due to COVID-19. While some hearings took place via remote means such as Zoom, I wonder how many litigants in person had the resources and the wherewithal to avail themselves of that option. I would like to illustrate the point using an elderly resident's case. He was conducting a civil claim for damages after a road accident which left him partially disabled. After obtaining interlocutory judgment, his next step to quantify his damages was delayed due to court closures. An application by him was dismissed by the court remotely, and he did not understand why. In the meantime, he suffered a stroke and is much weaker now. Time is of the essence to him. So my final point is, how have litigants in person been supported during COVID-19? And how can urgent cases be flagged out for expedited handling?
So we share Ms. Lim's concerns to the extent that we would, of course, want to support a litigant in person's access to our justice system. And I'm grateful to Ms. Lim for recognizing some of the efforts to handle litigants in persons in court. Both my ministry and the judiciary remain committed to ensuring access to justice for all. And indeed, one of the guiding principles of the Civil Justice Reform Committee, established by MenLaw, was to advance access to justice for all persons, including litigants in persons and SMEs. Let me highlight some of the other ongoing efforts. We are simplifying and streamlining legal processes and designing them with the ultimate end users in mind. The new rules of court, which is scheduled to come into operation later this year, will be written in modern, layman language, easy to understand and to apply. Forms and processes will also be simplified. Cases can take a judge-led approach where appropriate. Second, we are leveraging on technology to make legal processes more accessible and convenient, and to channel timely and useful information to those facing legal issues, especially litigants in person. For example, the Community Justice Centre, CJC's Automated Court Document Assembly System, or ACDA. This is a free online service that provides step-by-step guidance to generate and file certain court forms, such as applying for deputyship, which a layperson can do on his own. If necessary, court staff will also be available on hand to assist. Third, we have taken steps to enhance awareness and also support structures to help litigants in person. I spoke earlier about the improvements that we're making to legal aid for civil and criminal matters to support litigants of limited means who are unable to afford their own lawyers. The Community Justice Centre, CJC, also runs a one-stop help centre, HELP, helping to empower litigants in person. These provide support services such as free on-site legal advice and also emotional and psychological support through the Friends of Litigants in Person scheme. Elderly or less well-educated persons ought not feel intimidated or apprehensive in participating in legal proceedings. Ample support is available to help them navigate the court process. If the litigant struggles with English, the Community Justice Centre will endeavour to source for volunteers who are conversant in other languages. For litigants in person who require a court interpreter, they can make a written request, and the reason to have to make the written request in advance is obviously the number of interpreters might be limited. If all goes for Mandarin speaker or dialect speaker on the same day, there needs to be an allocation. So something in advance will be necessary. But to the extent possible, the courts will allocate the appropriate interpreter to ensure that the process can take place and that the individuals who do not understand English can still continue to take part in the proceedings. Certainly, the judge will not proceed with the hearing if one party is unable to follow the proceedings due to language difficulties. Ms. Lim asked about the translation of English court documents. For cases before the community courts and tribunals, or cases involving simple court orders, litigants in person who need assistance understanding court correspondence may call the court's hotline. They will be assisted by staff who can explain the content of documents to them, either over the phone or on occasion in person when they meet. For other cases, if a translation is required, litigants can be referred to third parties who provide translation services. We are in the midst of exploring the CDCs and with LSPBS, a range of options to assist litigants who need assistance with English court documents. And the avenues being considered are the platforms to explain the documents verbally in a language that the litigant is comfortable with, providing advice where needed, as you heard Ms. Heniso explain earlier, or in certain cases, assisting with the cost of engaging translation services where needed. Ms. Lim raised the case of a resident who was looking at quantification of damages. This resident can avail himself of any of the above measures I've mentioned. In addition, the litigant can also write to the court registry to explain the situation, ask for an earlier hearing date, and they can do so through any of the various modes I've mentioned. I spoke earlier about how MinLaw is working with agencies to review the CDMF, the Dispute Management Framework. Let me address the specific concerns that Ms. Lim has raised in her speech here. Cases are heard by district judges who are designated as tribunal judges. They are empowered to handle cases in a less adversarial way and to ensure that proceedings are simple for litigants to navigate. The CDRT is not bound by the rules of evidence, and proceedings are designed to be judge-led. These judges are trained in mediation, and they continue to assist every case. They continue to assist in every case, assess each case, and assess the parties for suitability in mediation, even as the case proceeds on an adversarial basis. If, despite all these measures, after exhausting all attempts at an amicable solution, there is still a dispute, then the CDRT will have to make a decision and issue an order. These orders then have to be complied with. Ms. Lim spoke about the residents' concern that they can be ordered to stay out of their homes. Let me explain. What Ms. Lim refers to are exclusion orders, which require the respondent to temporarily move out from his place of residence. Such an order is intended to deal with the most egregious of cases. There have only been 2 exclusion orders since October 2015. The CDRT can only make an exclusion order if the respondent has failed to comply with the initial CDRT order, as well as a subsequent special direction 2 times. The timeline in both cases for the EO roughly have been about 17 to 18 months between the initial CDRT order and the exclusion order. So for a period of more than 1 year, almost 1.5 years, this individual defendant has been disregarding the initial order, have been heard by the courts, and yet chose not to comply with the initial court order. Hence, where the court has shown evidence that the respondent is recalcitrant, continues to cause nuisance to his neighbor in contravention of the order, and remains in continuous default, it is only right that firm measures be taken to stop the offending conduct and deter the continuation of the nuisance.
In his response, he mentioned that there were avenues available for staff or perhaps through the CDC network to explain verbally to the resident the contents of the orders. But I wonder if he will agree with me that having a written translation is certainly something that is a better and a stronger reference point for the resident, because sometimes when people talk to you, you can't retain the information or you remember inaccurately, whereas if you have a translated document, you can refer to it and it is, in a sense, a more reliable source. So I'd like to ask again that the courts, through the CDC network or through themselves, do consider this avenue of providing a translation of court orders if such is sought by the resident and at a nominal fee or if not free.
Outlined earlier, this is something that's being looked into by the CDCs working with the LSPBS. In the appropriate cases, we can consider full translation of the court document. But I think Ms. Lim would also appreciate that it is not in every case that a full translation automatically means that the person who is receiving this document, even in its translated language, can readily understand it. And that's why the suggestion earlier that I made, which I think Ms. Heniso also weighed in on, is for pro bono lawyers to assist in this process, not just in the translation, but also in the elucidation and explanation of the impact of the document and what it means to the litigant in person. That said, I think we continue to ensure that through various means, we want to ensure that the litigant in person is able to understand the process, understand what the judge is saying, what the other party is seeking to achieve, and this, I think, upholds the integrity of the process. So we'll take these necessary steps to ensure that litigants in person will be able to understand the process through a variety of means.
Ms. Lim, would you like to withdraw the amendment?
Yeah, I mean, it's good to hear the court's continuing commitment to justice for all, especially litigants in person. And I would highly urge that the courts continue in this direction to address any gaps. And with that, I beg leave to withdraw my amendment.